All right, Amy Swearer is with us now. She's senior legal fellow at Advancing American Freedom. And Amy, I appreciate you being with us. Now you've had a little bit of time to digest what took place at the Supreme Court, the arguments. Yeah, everybody speculates based on what the justices ask and how they ask it and their tone. Set the stage for me about that hearing and your opinion now with a week behind it, what you think's about to occur.
Sure. Well, for those of you who may not be as familiar with the case, right, we're dealing with an executive order that President Trump issued, I believe, on day one of his presidency, defining more concretely what it means when you read the 14th Amendment's citizenship clause, and it says that you must be born here and also subject to the jurisdiction thereof for birthright citizenship to apply. And so the executive order drew a hard and fast line that I think is different from for many decades how people have understood it, which is basically just if you're born here, then you're a citizen. But it's based off of very real historical realities in which that was not always the case. In fact, when you look at how the framers of this amendment understood it, first of all, they weren't concerned with immigrants really at all. Their primary concern was making citizens of the newly freed slaves who, under Dred Scott, in earlier Supreme Court decision, the United States has said, you're not citizens based on your race, you can never be citizens, right? So they were trying to make citizens of these individuals who were there, who owed allegiance to no other foreign power, had been here for generations, and who, if they were white, we would have considered them citizens, right? But it's also very clear that they understood that they were making citizens of people, and only people who, like those newly freed slaves, were subject to the complete jurisdiction of the United States, who were not also subject to some foreign power, who owed allegiance to some other foreign power. So fast forward to today and what we saw at the Supreme Court with these arguments, I think most of us, even those who agree with the president's arguments here, knew that this is probably an uphill battle. I don't think we got some clear indication otherwise from the justices. I think in reality, what we saw is the messiness of this case. There's a statutory argument, and I don't want to get too far into the weeds here, but I think it's even more difficult to tell maybe how this turns out in terms of all of the options the justices can come up with. And I think that's a little unnerving. And I think part of this is, this isn't something on an issue like the Second Amendment or the Fourth Amendment, where these justices have a track record or a history we can point to sort of suss out from their questions how they might be thinking about this. This is an issue of first impression for all of them. And so I'm not overly optimistic, but as you've noted, this is an issue of great importance, not just because of questions of, well, the children of illegal aliens, are we incentivizing illegal immigration, but also there are very profound national security concerns for things like birth tourism, for children who are here only for the minute that they're born, and their parents are Chinese, Russian, Nigerian, foreign nationals who bring them back to that country, raise them in that country as loyal subjects of the Chinese Communist Party, but their kid has an American passport and we have to treat them like a citizen when they come back. That's right. Incredibly dangerous. So I'm not optimistic, but it's not a good thing to not be optimistic here.
When you look at the practical ramifications of 2026 with what people have been doing, I mean, when I first heard about birth tourism, I thought, God, do people really do that? And then I started asking around, including to immigration attorneys who do not agree with me on politics. They said, oh, yeah, this happens all the time. There are people who come to the United States. They come here on a visa. They know that they're pregnant, and this is the whole plan from the get-go. And there's nothing you can do about it. Do you think that the justices recognize that perhaps the intent years ago undermines the United States today, and that they would take action based on the contemporary writings at the time that this was passed that seemed to, based on what I saw immediately following the arguments in the Supreme Court, seemed to indicate that there were carve-outs to say, let's be clear, wasn't in the law, but let's be clear about who we're talking about, who we're not, that they would recognize that there is a danger now? Or will they kick it to the Congress and say, you've got to fix this. We're not going to fix it. If you want more clarity, if you want to define this in a different way, now you've got to go through a very long time, expensive and arduous process to change this.
Yeah, well, again, you sort of got all of that from various justices in these questions, because again, this is a bit of a complicated issue. I don't think it's complicated from an originalist perspective.
Yeah,
I think on the constitutional issue, and I actually found it quite interesting that most of the justices weren't actually going after the government's argument about that originalist perspective. Actually, I think a lot of the questions seem to focus on administrability and some of the statutory issues. So I think there is a possibility that maybe the Supreme Court or a majority of justices sort of kick the can on the constitutional issue, but leave it open and say, we're not going to let you do this via executive order. But if Congress wants to change the statute or statutorily define who's subject to the jurisdiction and who's not, then we might leave that open. So I think that's a very real possibility. But
is that normal, since you've been a longtime observer of the court, to default to the question actually being, God, if we step in here, we've created all of these other problems, so that needs to be preeminent in our mind rather than looking at the documentation of what's written on paper and what they meant at the time? Is this a normal debate, you think?
Well, so it's not necessarily unanticipated here. There is a statutory question. Now, the problem is the statute at issue says the exact same thing as the 14th Amendment. So essentially the ACLU, the other side of this, has made the argument, well, they say the same thing, but they were passed 80 years difference. And so when Congress passed this statute, they thought it meant everyone born here is a citizen, which might sound like a bit of a cop-out. I think it is a bit of a stretch based on how we normally interpret statutes. But it otherwise wouldn't be unusual for the court to say, well, we think the statute means this, and we're not going to, that resolves it. We're not going to get into the constitutional issue. I don't know that they will do that here. I think it's certainly an option. And it's an option that the ACLU has dangled in front of them in case you had any justices who might fall into that category of, well, I think it's constitutional, but maybe it's not politically expedient. So again, this is an unusual situation in many respects. But I think part of the reason you're seeing that being dangled is to take advantage of how unusual that is. Be like, do you want an out here that isn't what I think is the clear originalist answer about what the constitutional language means?
I found it fascinating that so many people went back through the archives and found editorials and floor speeches and contemporary material that offered some background. And I'm assuming that both sides were researching this to try to find advocates at the time for the position that they were advocating. How much of that should be weighed in a courtroom? I mean, I was not there and I did not get to watch the actual hearing, but is that relevant to this, that contextual information, or traditionally should jurists, especially at the Supreme Court, say, hey, I'm only going to look at what's right in front of me and I can't worry about everybody else's opinion who may or may not have been documented at the time of passage?
Yeah, so this is actually what it means to do originalism and textualism, right? Even to say, well, I'm just going to go with the text, you need to understand what that text means. And to an originalist, we would say, well, the rule of law means the words mean the same today that they did to the people who passed it. And so in that respect, trying to figure out how the framers at the time, how just the original public meaning, how the public understood this to mean at the time, that is very important on the constitutional issue. At least for you've got a majority of justices who claim to be originalists. That's going to be important. Which is why it was a little bit curious that most of the questions, in my opinion, didn't necessarily focus on the debates over, well, what did they mean? What did they not mean? But sort of looking at, even practical questions, again, like how would this work? Well, what does the statute say? I don't know. I think it's hard to guess which way that means they might be thinking on the constitutional issue. But you're right. There's a lot of underlying evidence that at the time, right, to the people who passed this, to the society that actually put this into the Constitution, they didn't mean everyone born here is a citizen. And in fact, some of the first versions of the amendment that they debated just said, if you're born here, you're a citizen. But they intentionally put in that phrase, that's subject to the jurisdiction thereof, for a reason. And it's because they wanted certain people excluded. Everybody agrees, for instance, that tribally affiliated Native Americans, right, at the time were not considered subject to the jurisdiction thereof. They're citizens today, but because of a statute we passed in 1924. Even the ACLU agrees, there were people they were trying to exclude. And it was about their allegiance, right? Because the tribally affiliated Native Americans were treated like quasi-foreign nations, right? And so the argument becomes, when you look at this, they understood it at the time as excluding people based on their lack of perceived allegiance to the United States, or at least significant allegiance to the United States. And for things like illegal aliens, which at the time there was no conception of an illegal immigrant, you have to sort of reason by analogy to say, well, based on this understanding, do we allow people to just unilaterally subject themselves to our jurisdiction? Well, no, we say you're subject to us repatriating you to your home country, right?
Right.
You don't unilaterally get to come in and say, oh, we're here no matter what. We've been here too long. We got away with it for too long. So those are all important questions, and it all plays into that constitutional question, at least for the originalists. Now, I think there are 3 justices on the court for whom that doesn't matter. Right, the law is whatever they want it to mean now, based on political expedience, and that's just going to be how they're going to reason through it, and they'll get to that any way that they can. But at least 6 justices, ostensibly, that is supposed to matter to them when they're looking at this.
Ketanji Brown Jackson made or asked a question or posited about someone stealing something in Japan, and that would make you subject to the jurisdiction of Japan. If I heard it correctly, and of course I want to be fair to her because I hear snippets, and if you're not sitting through the entire discussion in the courtroom, anything taken out of context can be twisted. But boy, she was widely ridiculed, certainly from the right and even some people on the left, for making that analogy. Is there something I've missed there? Was she making a point that was legitimate? I don't know if you want to take a shot at her directly, but objectively, is there some point she was making? She was
actually, believe it or not, unintentionally making the wrong point for her argument. There is a sense in which, and the framers of the amendment, when they're arguing over this language, they talked about this at the time. There is a sense in which everyone who is in the United States is subject to our laws, right? If I go to Japan, and this was Ketanji Brown Jackson's point, right? If I go to Japan, I don't get to just say, well, I'm an American, so I'm not subject to your laws, right? Can't prosecute me,
right,
in the way that you can't prosecute an ambassador, and that's true, but that's different from what the framers meant, and they made this point. The framers made this point. And it's why they chose this specific language. Like, well, we mean subject to the complete jurisdiction, meaning political jurisdiction. Things like rights and duties of citizenship attaching to you, where there's some meaningful political connection. So ironically, she makes this point about, well, if I went to Japan and stole a wallet, they'd prosecute me. Yes. And that is specifically not the type of jurisdiction they were talking about for citizenship.
Right.
You wouldn't become a citizen just because they'd prosecute you if you stole a wallet. That's not what it meant. And doubly ironic because Japan has some of the strictest citizenship laws. You have to really want to become a citizen of Japan. It's actually quite hard. So a lot of irony there that I think was lost in all of this. But her actual point is correct. She'd be subject to their jurisdiction to some extent, but the whole point was that's not the extent anyone means for citizenship.
Yeah. Well, looking ahead, when do we expect to hear from the court, and what do you think the options are with the decision that will finally come down? What are the possibilities?
I suspect that the court will hold on to this until the last day of the term, which is the end of June. I suspect that they'll probably release it, one, because they heard this one later in the term. This is a big, complicated case. It's going to take them a while to write the opinion on this. But also just politically, I think they will probably drop this on the last day of the term and then get out of D.C. so that the media can argue about it. So I'd look for it at the end of June, the middle of the summer, in there. In terms of their options, again, this is not something where it's just like they're going to strike it down or they're not. Right. There's an array of options. So on both ends of that, you have the best case for the government. They uphold the constitutionality. They say this is consistent with the statute. It's consistent with the Constitution. And on the other end, they could strike it down and say this is not only inconsistent with the statute, but it's inconsistent with the Constitution. And there's a whole lot of ways they could split the baby in between. In theory, they could say, well, it's constitutional for illegal aliens, but not for temporary aliens. Or it's constitutional but not consistent with the statute, right? Or Congress has to do it. So that there's an array of options. And I think there's even an option where none of the justices actually agree on who wins or why. Or maybe you have 5 say, well, it's unconstitutional or we're going to strike it down, but none of us agree on why. So it could be a mess. It could be 9-0 either way. I suspect, is slightly pessimistic. I suspect it'll be closer to striking it down, at least under the statute. I'm not sure you have 5 justices right now who at least obviously seemed to buy the government's argument, even though, again, I think it's the correct one. I just think there's just too much hesitancy and too many outs and off-ramps for them to use, unfortunately.
And I know you got to run, but let me ask you this. What's happening in the interim with people who are arriving at a port of entry and they're obviously pregnant and there are illegals who are running around Texas, maybe working, maybe not. I don't mean to impugn people, but this is the circumstance they're in. What's happening at this moment? If they were to give birth, that child would become a citizen as it stands currently?
Yeah, so my understanding is that the executive order has been enjoined from enforcement, so they're not able to enforce it right now. So the government would have to give citizenship documents. I will say, the Trump administration has done some great things in terms of trying to crack down on rules for issuing visas to no longer issue those visas to people who it's clear they're only here for purposes of birth tourism, which I think is good. That said, if people get around those restrictions, just like if they get around our other immigration laws, their kids right now are considered citizens.
Do they ask that question? Do they ask young women, hey, are you pregnant and when are you due?
They do. So it's, there's some sort of internal guidance with DHS and ICE about what that looks like. But that is a reason right now for them to deny visas, is to say, well, you're here primarily just for birth tourism. And I will point out, even if the Trump administration wins, and I think this is important, even if the Trump administration wins, Congress needs to solidify this rule. Because believe it or not, the Trump administration can win here and it doesn't matter, because the next administration can come in and say, well, retroactively, it doesn't matter. We're changing the rules because it's an executive order. So everyone's a citizen again. So whatever happens, there is an opportunity for Congress to step in and solidify, again, that original conception. You have to be not just here, but have a meaningful connection to this country, to participate in the life of the nation, to owe us your paramount allegiance, and not just be like, well, I was here. Citizenship is more important and more worthwhile than just the accident of birth on U.S. soil.
If the Congress were to get its act together and recognize that the window of opportunity is closing quickly for the trifecta of the White House, the Senate, and the House, for this president and for the Republican Party, if they were to get their act together and say, we're likely to lose this fall, but let's do some of the things that our voters care about. Have you looked at the legislative numbers to see whether something could be passed here with or without the filibuster being removed in the Senate?
Yeah, well, I think if it comes down to having to amend the Constitution again to clarify this, I think it's a long shot. I think if ever there were an opportunity, it's certainly now. But I think there would be certain things that just politically, it would be hard for even Democrats to look at that and say, no, that's a bad idea. Things like Saipan. So there's a loophole in some of our visa laws where if you're a Chinese citizen, you don't need a visa to come to Saipan. And so thousands of Chinese women just come to Saipan where they're, believe it or not, we consider their child to be a U.S. citizen if they're born on Saipan.
Ooh, Lord.
Yeah, a lot of people don't realize that, right? And so there should be even just things like that. Where
is anybody moving that, Amy? Is there anyone who is the immigration ambassador in the Congress who has got a grasp of all of these loopholes and issues and can try to put together comprehensive legislation to at least put the Congress on record? I mean, I want to hold my own people accountable. This is a little aside, but I am so frustrated that everyone worked so hard for the president to win, for the House to go Republican, for the Senate to go Republican, not with the numbers that we need, but and that I'm, for the second time with a Trump administration, the 24-month window is going to close. And in the end, we're going to say we still didn't deal with the big issues we've been debating for 20 plus years. When I was working in the Senate for George Allen, this was a topic that we discussed frequently legislatively, and nobody was able to actually execute on it. And it was really disturbing then. It's even more disturbing now that we've got a Republican president, a House, and a Republican Senate.
Yeah, so I think some of this is there are just so many things that Republicans can be focusing on. And I know the administration, certainly at the beginning, there was the focus on the One Big Beautiful Bill, which is great. Some of my colleagues actually today just dropped a booklet about some of the great things that are in that bill.
Send it to me. I want to read that.
Absolutely.
Please, thank you.
Some of this is the executive branch dictates a lot of policy.
Yeah.
But you're right. There are certainly things that Congress can do and can focus on outside of simply throwing up their hands and saying, well, we're waiting to see what the Supreme Court does on this. Because again, even if the Supreme Court sides with the president, Congress has to act to make sure that it matters in the long run. So certainly something that I anticipate Congress and the Trump administration will pivot to, maybe using whatever happens in this opinion as that pivot point, that linchpin. So maybe some of this is political expediency, right? To take advantage of again, whatever happens in that opinion, it will certainly be the news of the day. So I'm more optimistic. I haven't given up hope yet, and I don't think you should either. But I think this is something that, again, voters and people who, just Americans, right, need to be showing that they're concerned with this, that this needs to be a priority. And I think it's, out of all the priorities that we can have, a pretty darn good one.
I agree with you. I think it's preeminent. Amy Swearer, Senior Legal Fellow at Advancing American Freedom. This was great. I really appreciate you taking time to talk to us today, and maybe we'll chat again soon. Certainly when the decision comes out.
Absolutely. I look forward to it.